All right, y'all, man. So DPS has responded. Texas Department of Public Safety. They had 10 days. They responded within the 10 days. And whether I like the response or not, you guys know I asked ChatGPT prior to getting their response back, will DPS do the same thing that the DA's office did? And they freaking did. So um, they asked the Attorney General, for to make a ruling because they want to withhold information. But let's kind of go ahead and get into it. I'll tell you guys my request, what I sent, and then I'll tell you guys their response, and then what their briefing to the Attorney General's office. So this is what I said. Dear Public Information Officer, pursuant to the Texas Public Information Act, Texas Government Code, Chapter 552, I'm requesting access to and copies of records related to DNA testing conducted by the Texas Department of Public Safety Crime Laboratory in the case of the state of Texas versus me, Jonathan, right? Galveston, Texas, 2015. Says I'm requesting the following records, including any materials authored, reviewed, or handled by Stephen Adam Vinson. Y'all guys need to go Google that name, Stephen Adam Vinson, Vinson. And it was about 438 more cases, maybe more, that he ran DNA on back in 2013. So it's a lot more people out here who had the DNA ran by this guy. So it says, all DNA laboratory reports, initial, supplemental, amended, or final. All DNA quantitation data showing the amount of DNA recovered from each evidence item. That's crazy how they put it together. It says all raw electropherogram files, FSA, HID, or equivalent, or interpretation summaries, analyst worksheets, bench notes, and technical review notes. Chain of custody documentation for all evidence tested. Records identifying the STR or YSTR kit and software used. Any records reflecting retesting, reinterpretation, or review of DNA results. Any internal communications related to DNA testing or analysis in this case. Says, please provide these records electronically if possible. If any records are withheld, please identify the specific statutory exemption relied upon and release all reasonably segregatable non-exempt portions. Please confirm receipt of this request. Sincerely, me, Jonathan. So that was my letter to those guys. You know what I'm saying? I talked to my friend, man. My friend ChatGPT put me on what I needed to be put on to send this letter out. You know what I mean? Formal letter to these guys, DPS, so they can reply back to me. Let's get into it. All right, y'all, man, we back. So after going over the DA's response, your brain be moving 1,000 miles a minute. So I had to go to my best friend and ask ChatGPT another question. So I asked, will DPS take me through the same process if they don't want to release records? I just had to ask the question, dog. Like it popped up in my head. So it said short answer, yes. It said DPS will follow the same basic Texas Public Information Act process. If they decide they don't want to release certain records. It says, but there are some important differences between DPS and DA's office that actually work in your favor. Just let me break it down clearly. Because number one, the rule applies to all Texas agencies under the Texas Public Information Act, TPIA. It says any Texas government agency, including DPS, must either release records or ask the Texas Attorney General for permission to withhold them. It says the DPS does not get special treatment. It says if they want to refuse your request, they must ask the Attorney General for a ruling within 10 business days of receiving your request and notify you that they did so. I haven't gotten an email back yet, but it says exactly the same framework as the DA's office. Says the key difference between DPS, here's the important distinction. The DA can claim broad privileges like attorney-client privilege, work product, internal strategy, but DPS is a forensic laboratory, not a law firm. Sounds good. Says that means most of what you're requesting from DPS is scientific data, testing records, lab reports, chain of custody, bench notes. Those are not normally privileged. It says so DPS has far fewer legitimate reasons to withhold records. Number three, what DPS can realistically try to withhold? It says DPS might try to claim exceptions such as ongoing investigation exemptions, personal identifying information, victim privacy, but they would have a very hard time withholding things like electrophorograms, files, DNA quantitation data, lab reports, analyst worksheets, bench notes, testing logs. Those are routine forensic reports that defendants and the public regularly obtain. Says likely scenario with DPS. There are only a few realistic outcomes. Scenario A, best case, DPS simply release the records without resistance. That'd be good. No AG process needed. Scenario B, partial release. They release scientific records but redact phone numbers, addresses, victim identifiers. Come on, take all that up out of there. Just give me what I need, man. You can have it. You can have it. We don't want to fight. Scenario C, they seek AG ruling. If they try to withhold anything substantial, they must send the request to the Attorney General's office, provide legal argument, copy you on the process, just like the DA is doing. If DPS fails to follow the rules, just like the DA, if DPS just like with the DA, if DPS does not respond within 10 business days or seek an AG ruling in time, the information becomes presumed public by law. Says so deadlines matter a lot. So then it says why DPS records are more powerful than DA records. It says remember, DA emails show what prosecutors know. DPS records show what science actually said. And DPS records are harder for the government to hide because they are objective lab material, not legal strategies, not attorney communications. Says number 7, practical bottom line. Yes, DPS could try the same attorney-client route, but they have weaker grounds. The AG usually order release of forensic material, and you have stronger rights to that data. Most important point. Even if DPS tries to involve the Attorney General, that is not a dead end. Says it just becomes another step in the paper trail showing what existed, when it existed, and whether the state tried to hide it. Says which in your case is exactly what you need to prove. man. I'm telling you, boy, ChatGPT come in handy. And so that's the difference between the DA and the DPS. So, like I said, it just got me on cloud 9 right now. You know what I mean? Release them endorphins, and I'm just ready to go to work again. I'm ready for emails to come back in so we can keep the ball rolling. But make sure y'all like and subscribe to the channel, man. Follow me through my journey, bro. Like, I'm trying to take y'all on a ride with me, man. And like I said before, this is not funny by no means. You know what I mean? Like I said, I laugh a lot, I smile, whatever. But this is very important to me, and I'm really giving it my all to clear my name. So like I said, man, make sure y'all like and follow, subscribe, do everything, share, and catch you on the next one.